Criminal law, part 1. Elements of a crime. Mens rea, meaning the guilty mind. Actus reus, that is the unlawful act. And causation. Looking at the actus reus, the act. The act must be voluntary, meaning a product of the actor's determination, or the failing of a legal duty to act. Looking at mens rea in specific intent crimes. The mens rea in specific intent crimes can be determined from the fact pattern. What degree of guilty mind is required can be determined from the fact pattern. The fact pattern defines crimes as requiring, quote, the intent to, end quote. This is a subjective desire, specific objective, or knowledge to accomplish the prohibited result. Mens rea in malice crimes. Malice crimes are common law murder and arson. The mens rea can be inferred from the reckless disregard of a high risk of harm, conducting a criminal act without an excuse, such as self-defense, and or the intent can be inferred from accomplishment of the act. Looking at mens rea in general intent crimes. General intent crimes, battery, rape, kidnapping, false imprisonment. The mens rea here requires only the intent to perform the unlawful act. That is, knowingly, recklessly, negligently. Looking at the mens rea in strict liability crimes. In strict liability crimes, mens rea is not required. The only thing that is required in strict liability is the actus reus. The act is sufficient, such as statutory rape, selling liquor to minors. This includes regulatory offenses for public welfare, such as speeding. Very familiar with that. Strict liability, however, is generally disfavored. That's from Gypsum Company. Light penalties for strict liability offenses are okay. Severe penalties and a mens rea is required. It cannot be strict liability. Looking at defenses. Defense of mistake of fact. The defense of mistake of fact is available, but it must be an honest mistake. For a specific intent crime, the mistake may be unreasonable. Again, that is with the intent to. Mistake may be unreasonable. However, with general intent, that is knowingly, recklessly, negligently, or common law murder or arson, the mistake may not be unreasonable. Specific intent, mistake of fact, may be unreasonable. General intent, mistake may not be unreasonable. Defense of mistake of law. It's only a defense when the actor is relying on a decision of the court, an administrative order, an official interpretation of law, or a statute newly outlawing activity is not reasonably made available prior to alleged conduct. And an honest mistake of law is available as a defense, such as believing one can use self-help to reacquire property. Jurisdiction and constitutional limits on authority. The state police power is recognized in the 10th Amendment. Federal government has no police power. Federal government has no common law of crimes. They're all by statute. Neither the federal government nor the state may criminalize conduct that has already occurred or impose criminal liability without a clear warning as to prohibited conduct. That is through the 5th and 14th Amendment. The 14th Amendment applies the 5th to the states. Territorial considerations in jurisdiction. Federal government has jurisdiction over federally owned and or controlled territory, conduct by the United States abroad, and aboard ships and planes. The state has jurisdiction over crimes committed fully and or partially within the state, and conduct outside of the state for purposes of committing a crime within the state. Looking at the parties involved in criminal activity, the principal is the perpetrator of the crime. They are actively and or constructively present at the scene of the crime. The accomplice covers a couple designations, such as an accessory before the fact or a principal in the second degree. But generally, an accomplice aids or abets a principal prior to and or during commission of the crime with the intent that the crime be committed. A principal in the second degree is physically and or constructively present at the crime, such as the getaway driver. An accessory before the fact is neither physically or constructively present, but encourages or assists commission of the crime. All of the accomplices, both the principal in the second degree and the accessories, are liable to the same degree as a principal, even if the principal is not tried or convicted or even is given immunity. And that concludes Part 1 of criminal law.